Hi, good morning. I'm Rachel Valentine, your parent liaison, and this is Misty Lynch, one of our transition specialists. This morning we have Adriane Grace presenting to you how to protect your special needs child, guardianship, and alternatives. And now I'm going to turn it over to Miss Grace.
This is just to tell you a little about me, and I have a small version on my phone, so I'm going to have to look at my phone. I've been practicing law for almost 15 years. I'm licensed in Texas and Virginia. My first job out of law school in DC was with the Social Security Administration. I worked for the Appellate Division reviewing disability decisions. So I got a lot of experience about medical conditions and just how they impact people's functional abilities, especially in the vocational environment and the work environment. And then when I moved here to Texas, I got into estate planning, especially special needs planning, guardianship work, and I also do probate. I've done a little bit of fiduciary litigation in the past, but right now my practice is limited to court proceedings where the families are agreed. So a lot of guardianships for where the parents are trying to become guardian of their young adult child who's becoming 18, and sometimes elderly parents who later become unable to take care of themselves if the siblings in the family are agreed about what to do. So we'll go to the next slide. Okay, so I like to talk about, even though this is billed as a guardianship presentation, if you're here to know more about guardianship, you probably want to know, your bigger question is like, how can I protect my child who has these medical conditions or disabilities, and protect them given all of their limitations. So when I talk about how to protect your child, I don't just limit my conversation to guardianship. I want parents to know about the other ways they can protect their child. So becoming their legal protector through a guardianship is one way, but we also want parents to advocate for their child, of course, just like they did in the educational system for accommodations or special education. When they turn 18, make sure they're getting access to all community supports and services that are available to them, and we're going to go into that a little bit, because sometimes they can't advocate for themselves. You're going to be their advocate, so it's really important that you're educated on those options for them when they turn 18. And some of these things, your transition coordinator will tell you you should get your child on the wait list like at 3
Yes.
or 4, because we have 15 to 20 year wait lists for some of the programs in Medicaid. And then finally, I want y'all to think about your legacy for them. You've been caring for this child, but you will not be here forever. And I just went to a wonderful presentation by a doctor in Dallas who treats specifically adults with Down syndrome, and their average life expectancy is now 60 years old, meaning some of your children are going to outlive you. You need a plan about who is going to be your successor in caregiving, and you need a plan about how you're going to pass on a financial legacy to that caregiver to care for that child in a way that people aren't going to take advantage of your child. So that's what we're going to talk about today. All right, so first of all, we're going to talk about guardianship because that's what everybody is here for. All right, so what is a guardianship? So this is a legal process. It is something that we file in court. In all of our North Texas counties, we have specialized courts called probate courts. We have, I think, 2 or 3 in Tarrant County. We have 2 in Denton County, 1 in Collin, and 3 in Dallas that handle specifically probate cases when someone passes, but also guardianship cases. So the nice thing is we have judges and we have attorneys who are really knowledgeable about guardianship and about, your children and what they're going through. So that's a really nice thing. But it's very important to understand when it's appropriate to do a guardianship, like when we can convince a judge that a guardianship is appropriate, and when we might need to look at alternatives. So a guardianship is that legal process for not just giving the caregiver the legal right to make decisions for their child, but also we are stripping away these rights from your child at the same time. So it's considered an adversarial proceeding because your child might not be able to have the right anymore to vote, to drive a car, to make a decision about marrying, in addition to things like you deciding their residence and you deciding all their health care choices and you deciding what jobs they get and how they spend their money. So courts really scrutinize cases that come before them about guardianship, because Texas doesn't want to take away people's individual freedoms and rights. So we have to consider, you know, whether guardianship is appropriate and if there are any alternatives. But there may be a need for guardianship in some cases where it might be borderline, not just to give the caregiver decision-making authority, but also to protect the individual from exploitation. So sometimes stripping a parent's right to marry, a child's right to marry, is a good thing. So I have 2 client stories about that, which I'm just gonna give vague facts so you can't match, where this has come up. Recently, I was approached by a parent, and this parent was able to get their adult disabled child on disability benefits after they turned 18. They were able to get them benefits under the deceased father's work record. And so because of that, the deceased father had $2,600 a month in benefits for this disabled child under this particular Social Security program. But one of the rules was if you get married, that those benefits go away. And when I was interviewing mom, it turned out the adult child had some intellectual disability. The adult child had been adopted from Eastern Europe, and a lot of the kids who have been adopted out of there have a lot of heavy metal poisoning and fetal alcohol syndrome, and so they appear normal, but they are intellectually disabled from, you know, the environments they came from. And so we discussed this, and we discussed, you know, the possibility that, mom's very involved with this adult child, lives with the adult child, but we discussed the possibility that after mom was gone, it was very possible someone would want to marry the child for the benefits, and then of course that would go away. So we talked about it, and there were some other things like the child was considering a bariatric surgery, and mom just didn't feel like the child could really understand all the consequences of that surgery and consent. So we got the guardianship. The adult child was probably, their IQ was in the mid-70s, so they were a little bit borderline. They had a driver's license and were able to drive. So we gave this child the right to vote and, you know, the right to drive as part of the guardianship. And then a little part of you know, us was, well, we hope we made the right decision. And then right after that guardianship was done, I had an adult brother come to me, and a brother had an adult sister that he is now we'll say the supporter of. There's no guardianship of this adult sister, mainly because the parents who had passed away didn't want any kind of label on their child. And the adult parents had been successful getting the adult child on SSI when the adult was in their early 20s, because the young adult had a combination of physical and mental, but they only reported the physical limitations to Social Security. It was enough to get SSI. And then they did nothing more. And this adult child, who everybody knew, like, just this had been in special education and, you know, had a lot of mental limitations, was married twice, was exploited in all sorts of ways. Her child was exploited and is now institutionalized. And, you know, when brother came, and then the parents didn't do very good estate planning. So the brother ended up coming to me because the trust that the parents created was not acceptable by Social Security, and they had gotten a letter about it, and the benefits are about to be terminated. And I just felt really good about the other case because I realized how important it was to make sure that the parents start out right. They get the guardianship to protect the child. They secure the proper benefits for the child's disability, and also, you know, make sure the estate planning is in place so those future caregivers, like the adult siblings, have a much easier job. Okay, so let's talk about the mechanics of a guardianship, like what goes into this, who are the parties. So we have the proposed guardian or guardian, which is usually the parent or caregiver who's applying to be the legal guardian. We call the disabled person that we're getting a guardianship over the ward, the proposed ward. Sometimes the courts say the proposed protected person. And as I said, since it's an adversarial proceeding, meaning the court is going to take away the young adult's rights, they have a right to a court-appointed attorney. And this is an automatic appointment. So the court appoints an attorney ad litem to represent the disabled adult's interests in the case. And we just had a change in the law effective September 1st. The attorney ad litem is supposed to advocate for what the young adult wants, or what the proposed ward wants, because it could be an elderly person, but in this context we'll say young adult. So if your child tells their attorney, well, I'm fine with mom and dad continuing to take care of me, then legally that is what the attorney is supposed to advocate for. And then in some cases where, there's a disagreement, maybe the adult child is disagreed with the guardianship. Maybe they don't want it because they know that they won't have the right to marry if there's a guardianship, or they can't decide where they can live. Then the court may appoint a special person called a guardian ad litem, and their job is to interview everybody involved, look at the medical evidence, and make a recommendation to the court about whether guardianship is in the disabled individual's best interest or not. So as you can see, it's the other piece of this is that there's also court investigators involved who are investigating. So it's really important to visit with legal counsel, especially if you're not sure whether guardianship is appropriate for your child or not, so that you can really dive into your facts of your child, their condition, your goals for them, to see if guardianship makes sense, because you don't want to get into this process and involve all these parties and spend a few thousand in legal fees to find out that the court doesn't want to grant your guardianship. So when can you begin the process for guardianship? So for a young adult, we can actually put the application in on their 17-and-a-half birthday. And I highly recommend that if you're wanting to make sure that there is a court order in place on the day they turn 18, or at least close to it. And there's good reasons for that. I'll get into that. But the court process, it takes time. The courts are slow. They have a lot of cases. All of our North Texas counties are super busy with the probates and guardianships, and it generally takes months to get through the legal process. So it's good to file the day your child is turning 17-and-a-half. So what does that look like? You probably need to back up and start the process somewhere around 16, 17 to make sure you have the medical evidence that'll be necessary to get the guardianship, and I'll talk about that in a bit. But most importantly, if you know your child has significant limitations in their ability to communicate, like they're not good with talking on the phone or talking to strangers, then you're gonna have problems getting things like SSI and Medicaid, because the Social Security Administration doesn't recognize power of attorney. So even if you could get your child to sign a power of attorney, they will require them to be on the phone with you and give permission to talk to your child every time you need to talk to the agency. So if that is a problem for your child, you will probably, and you want to get SSI, you will probably want to get that guardianship ready and in place for their 18th birthday, so you have no issues stepping into their shoes and being their advocate with the agency. And again, I mentioned this already, but we apply for guardianship in our probate courts. Okay, so we actually have two types of guardianships. Generally, however, for young adults, we're just doing guardian of the person. We also have guardian of the estate. So the rights and duties of the guardian of the person are decision-making concerning their person. So where they live, their medical care, who they marry, things of that nature, their employment. Anything having to do with money, we give to a guardian of the estate. And it's not really two different people, it's just two types of pathways in the legal proceeding. Most young adults don't require a guardian of the estate because they generally don't have money of their own unless a grandparent left them an inheritance or a parent left them an inheritance and that hasn't been dealt with. Otherwise, they really don't have money of their own. Additionally, effective September 1st, guardian of the person now gives the legal guardian of the person the authority to manage up to $20,000. Why? Because we know a lot of our young adults want to work and they're going to work part-time. And so mom and dad, especially if they're going through the Texas Workforce Commission for job training, so mom and dad, you may need to help them with managing their income from work. So we don't need to get guardian of the estate just to manage work income. All right, so let's talk about who can serve as guardian. There is an order of priority about who can serve as guardian. For young adults, their parents are the most obvious choice. So there's generally no issue with a mom and dad being appointed co-guardians of their young adult aging out child. With regard to married parents, no issue. With regard to parents who are not married to each other, the rule is they can be co-guardians if they have an existing SAPSER case. That's a suit affecting the parent-child relationship where the parents have an order on child custody and child support, and the parents were appointed joint managing conservator. That's where the parents were given the equal right to manage their child and make decisions about them. In which case, they can become co-guardians. And indeed, I've had divorced parents who co-parented very well and were co-guardians of their child. We can even craft like visitation agreements through the guardianship as well. Additionally, I've also assisted where parents weren't involved. So if there was a grandparent who was a caregiver, especially if there was a SAPSER where the grandparent had been appointed a conservator or other kin, I was able to put them forth, and then we either got a waiver from the parent or we just served them and let the court know why they were not suitable to be the guardian. Some families don't have very good options for who can serve as guardian. There are some qualifications to that, or they fight and don't get along. The court can appoint a private professional guardian. And so this is someone who's licensed by the state of Texas. And I promise you, it is not like that Netflix movie. What was it called? I Care a Lot.
No.
I was like, that's not how it works. The private professional guardian is licensed, and a lot of them are like former social workers. Some of them are attorneys who've worked in the guardianship system a lot and are very experienced. And they can serve for a fee, including if your child's only on SSI or Medicaid, they'll get a stipend out of that Medicaid. I think it's like $250 a month. So that is an option. We do have like one of our counties at least, Denton County. I don't know, are y'all?
They're mostly all Dallas County.
No, y'all are mostly all Dallas County.
Yeah.
I don't know that Dallas County has a public program, but Denton County does. Denton County has MHMR. They serve as private professional guardians as well.
Okay.
The court can also consider the preference of the proposed ward. So perhaps in the case of divorced parents, if the adult has a preference for one parent over the other, the court can consider that. An appointment is made considering what's in the best interest of the disabled person. All right. Okay. So we do need to be aware about when a court might not say yes to you being appointed as guardian, because you certainly don't want to go through the process of paying filing fees and legal fees and find out that you're not a person the court would want to appoint. So obviously they're not going to appoint a minor child or another incapacitated person, like someone who has dementia or the like. you know, they're not going to appoint an inexperienced person. So I had one where I had some twins who were orphaned, and they were just so young. One was neurotypical, and we ended up getting a private professional guardian because the neurotypical twin was only 19, 20. They were just too young to be the guardian of their autistic twin sibling. So, you know, I really didn't want to put them forth and have the court say you're too young. The court's not really going to want to appoint someone who's convicted of a felony, or who has some kind of ongoing investigation, or who's been convicted of any kind of crime involving endangerment to a child or an elderly person. And in fact, if you are in the middle of some kind of Department of Family and Protective Services investigation, they generally won't appoint you either because they want to know the outcome. And sometimes that comes up with disabled people who are particularly oppositional, or they suffer from severe mental health problems. Sometimes they end up calling APS and complaining, and then there's an investigation, even if it's totally groundless. But that is going to make the court stop and say, well, I don't want to appoint you until I know what the outcome is here. And of course, the court can also decide for themselves, like, I don't think that this person in front of me is suitable to be a guardian. And that can be very subjective. Additionally, the court doesn't want to appoint anyone who has a conflict of interest with a disabled person. So think about something financial. Maybe they owe money to their child, or they're in a lawsuit involving the child's welfare or property. This could maybe come down to maybe an inheritance or something of that nature. Okay. All right, so we're going to talk about the medical evidence I hinted out earlier. So it's really important to know that the court is not going to take your word for it. You got to prove the medical evidence that supports the need for a guardianship, that supports the need to strip your young adult child of all of their constitutional rights and make you the legal guardian. And the way we do that is through a form called a certificate of medical examination. There's a specific form that the courts like to use, and it's basically like it's 4 pages, and it's asking the doctor to answer all these questions about the person's limitations. Like, for example, can they make healthcare decisions? Can they consent to like certain types of medications? Can they engage in activities of daily living totally independently, like bathing, showering, toileting? Can they manage money? Things like that. It asks a series of other questions, and then if your child has an intellectual disability, it will ask the physician to complete a box with like what's their estimated IQ, and did they come up with this based on the state's rules on determining intellectual disability. So you can see that when I mentioned before you could file on your child's 17 and a half birthday, there's some legwork to do here, because the certificate has to be based off an examination of your child. So there may be time that you need to get your child into their doctor's office, have them examined, so that the doctor can complete the form based on that examination. If your child is kind of borderline, like some of my autistic kids, they are slightly intellectually disabled in that their IQ is somewhere between 70 and 80, and maybe they can participate in some of the general education and school, but they do have a lot of social limitations that really make them vulnerable to being exploited, or some of them even just like can't do basic certain activities of daily living, right? Like, you wouldn't know it talking to them, but their parents tell me I still have to wipe his butt. So it's really important that you get all the medical records, maybe complete, maybe update your neuropsych evaluations if your child's had an evaluation. it's been a really long time, like maybe they were 10 years old, it might be time to update that. Take them to a neuropsychologist and see where they are at age 17. And all of that evidence can be really helpful because not only are we going to give it to the court, but we're also going to give it to those other parties that were on the other slide. So when the court appoints the attorney for your child, and if your child is saying, I don't need a guardianship, I'm fine, you'll have that extra evidence to give to their attorney so that there's correct advocacy, shall we say. Additionally, as I mentioned, all of these probate courts have their own court investigator's office. Tarrant County, Denton County has a very involved court investigator's office. Dallas County has a court investigator's office. And that's more supporting evidence you can give to that court investigator because they also file a report as part of the guardianship where they tell the court whether they think your application is valid and that a guardianship is needed. So getting a head start around 17, 16, gathering this information, that can help. I've also surprisingly had a lot of parents who never really did the intellectual assessment, or they have a very old one from when their child was less than 10, and I really feel that those should be updated, especially if there's a plan to get your child on SSI. Social Security is going to want an updated intellectual assessment that's based on testing for an adult, because how we assess a child's intellectual ability is different and a different kind of testing than we do for an adult who's close to 18. And then sometimes, I was just going to say sometimes we need to bring in testimony of family and friends. I had another case with kind of that borderline autistic child, bless you, and that the young adult was had some really good functioning skills, social skills, even to the point that the parent could leave them home alone for an hour or so after school. They knew how to call a neighbor and 911 if there was an emergency. They played the ukulele, they played the piano, they were in some gen ed, but they, for some reason, lacked insight into when they were not healthy. They didn't seem to be well connected into what was going on with their physical body and lacked insight into that, especially if they were injured or in pain. And so we had family come and testify about specific incidences of that and why we needed a guardian and advocate on the healthcare side. Okay, so a common question people have is, do I need to hire an attorney? And the answer is yes. There's no such thing as a pro se guardianship. Pro se is Latin for do this legal case on your own. People can be pro se on many things in Texas. They could do their whole divorce and child custody pro se. I don't recommend that. But you can. You can file a civil suit. You cannot do that in a guardianship because, again, we're talking about a proceeding where we're stripping away your child's constitutional rights to give them to you. So the court requires you to be represented by an attorney to advocate in that process. Next question I commonly get is, how much do guardianships cost? And I'm going to give you the lawyer answer. It depends. The one fixed thing are the fees in the guardianship. You can go to each county and see how much the fees are, but it's pretty expensive. It's close to $500 just to file a new guardianship application. There's a lot that goes into it. Sometimes we're having to pay court investigator fees. We also have to pay service fees. Your child, since they're getting their rights stripped away, they have to be personally served in the state of Texas by a sheriff or constable. So that's a little unnerving for some, and for other kids, they're like, yay, police car in front of my house. But that's the rule, and so there's fees that go into that. And then that attorney ad litem, the attorney that represents your child, Well, guess what? You have to pay their legal fees too. Some courts limit it. There's a judge in Tarrant County who fixes it to $500, but the other courts don't. You'll pay a deposit of around $500 or $600. I think all the courts have raised it to $600 this year. And then if that attorney spent a little bit extra time, they could ask the court to award a higher fee. So you have to be prepared not only to pay your own legal fees, but the fees of your child's attorney by law. All right. I will say one more thing about cost. Attorneys who handle guardianships handle them differently. Some attorneys do it on a fixed fee, and some attorneys do it on an hourly basis. When you're evaluating who to hire, decide what kind of matter you are. Are you truly simple, like mom and dad? I would say simple would be married mom and dad trying to be guardian of their child, where there's no question they need a guardianship. They are profoundly disabled. They have no ability to even communicate for themselves. Those cases are pretty simple, like open and shut, shall we say. And if you're parents who don't really feel like you need your hand held, there are a lot of attorneys in Dallas who offer pretty low fixed fees because they're not really going to be there for you other than the day you show up in court, and that may be totally fine if budget is a concern. And then other attorneys you may pay an hourly rate to, and you'll have the opportunity to talk to them and be advised and guided. So just make sure you understand that. Whoever you're interviewing, always ask if it's important to you to get advised by the attorney throughout the process. If this is a fixed fee, how many hours of time am I getting with the attorney? All right, so now that we've talked about guardianship, let's talk about alternatives to guardianship. So, what is an alternative to guardianship? It is oftentimes a legal document where if we use this legal document, we could honestly say we can avoid the need for a guardianship. But it must be feasible. It must be something we can actually implement given the facts for your child's case. And it may require the assistance of an attorney to help with drafting and advising. We always want to consider alternatives to guardianship because the Texas legislature requires it. So because, again, we're talking about stripping away a person's constitutional rights, we now have to state in our applications and when parents appear in court whether we considered alternatives to guardianship and if they were feasible or not, and whether we considered supports and services that might avoid the need for a guardianship. And the probate court and the court investigator's office, when they're looking at the application and the evidence, they're also thinking about, hey, are there alternatives that I can recommend to the judge? Is there a support or a service that could avoid a guardianship? All right, so here's some of the alternatives to guardianship that might be available for certain fact patterns for a guardian of the person and a guardian of the estate. In nearly all cases, we are going to look for an alternative to guardianship of the estate. So even if we're getting a guardian of the person, we may have an alternative to guardian of the estate. An actual guardianship of the estate is pretty expensive because there's a lot of reportings and accountings and mother may I's that have to go on in a guardianship of the estate. So we really try to avoid that entirely. Guardian of the person, however, this is a question about your own child, whether your child has the ability to understand and sign a legal document. And I would encourage y'all to get legal advice about that and not make your own individual assessment, because I see a lot of chatter on the internet and in all the Facebook groups and everything, special interest groups, about power of attorney, and I feel like power of attorney in the elder and special needs community is probably the most abused legal document because people think it's a substitute for, getting a legal protection in place because it's cheaper and easier and available, but indeed what you might be doing is just even violating that individual's rights or, your own fiduciary responsibilities to the person. So we want to evaluate whether, legally speaking, the person who might sign a power of attorney can legally sign it because it's like a contract, right? And you wouldn't want your kid to sign a contract they don't understand, or much less a contract they can't even read. Anyone signing a contract needs to be able to understand the business they're entering into and what they're giving up and what they're getting in exchange. And if your child doesn't have the mental ability or capacity to understand those complexities, then power of attorney is not appropriate. The other option is a supported decision-making agreement. This one is not like a power of attorney. It's kind of its own special thing that Texas has created. You can find it online, and basically the supporter, which is usually the parent or other caregiver, sign it along with their adult child, and it allows them to participate in discussions with third parties and decisions with third parties. So think of like an employer. So if your child is going to be working, you might want to be more involved with the employer than the normal adult, and presenting them with a supported decision-making agreement should allow them to have conversations with you about your child's employment, which they normally wouldn't have for an adult person. We can also do a medical power of attorney. That document is available if at any time a doctor decides your child is not able to make healthcare decisions. But with all of these documents, it's important to understand they don't take away your child's decisional capacity, right? So they really only work if you have a young adult who is cooperative and trusts you and really looks to you for support and guidance. If you have a child who's got mental health comorbidities and is oppositional, these documents aren't going to help because they're going to go off and do their own thing. And then you won't have the protection of a legal proceeding to, say, call the police and have the child brought back to you. When we get a guardianship, we get a court order, and at the end of that court order, in all cap, bold, underline, is a notice to the police that they are required to bring this person back to the guardian if they're found. Whereas if we don't have a guardianship and your child takes off with somebody or just takes off, some of our autistic kids, they get overwhelmed and they go for a run, and you don't even know they bolted from the house. Well, once they turn 18, they're going to get treated like any other adult missing person. The police are going to wait it out for a couple of days, and that could be really detrimental for some of these kiddos. So you really have to consider that as well, that you can have these documents and they're useful, but only to the extent that your child is, I want to say, even complacent. Like they're just like, I'm good being at home, I'm good being with mom and dad, I only do what mom and dad say, and I trust everything that they tell me. And then for mental health, we have the emergency protective order and the mental health commitment. We actually cannot use a guardianship to commit somebody to a psychiatric facility. So I get a lot of phone calls from parents of adult children going through a mental health crisis or a crisis involving substance abuse, and they want to get a guardianship, and I have to inform them, well, we can't use a guardianship that way. Even within a guardianship, if the ward was having a mental health breakdown, we'd still have to use this mental health commitment process, which is a separate legal proceeding, to get them involuntary inpatient psychiatric care. So the most that the guardian can do, however, is they can transport the individual to a psychiatric facility for an evaluation. So that's helpful, but they cannot force the issue. All right. Okay, so the other thing I mentioned is that the court also asks us to consider supports and services that might avoid the need for guardianship. These are things like your community programs for housing, our public benefits programs like SSI and Medicaid, vocational support, and those things. But again, if your child is not able to independently engage these services and supports, then they're probably not feasible. That's how the legal definition works. All right. Okay, so I want to talk a little bit about these public benefits because a lot of times parents want to get the guardianship because their child cannot communicate or has these limitations, and they definitely want to make sure to get them on SSI so that they can also get Medicaid. So I think they go I think the discussion goes hand in hand. So there's different kinds of Social Security benefits that are available for young adults who've never worked. SSI is generally the program they're going to be applying under, especially because they also don't have any property in their own name. SSI is basically, it's a welfare program. I worked for the Social Security Administration, so I can say that. That one is coming from the general tax fund, and so because it's coming from the general tax fund, the U.S. government has determined that it's only for the most neediest people. So they have income limits and they have asset limits when it comes to SSI. But most young adults can meet that because they don't have a job, so they don't have any income, and they don't own any property, so it's pretty easy for them to meet that. Additionally, once a child turns 18, they stop looking at the parents' income and resources. So for a lot of parents, and probably a lot of y'all here today, you won't be considering SSI until your child turns 18. Like if you tried to apply now, your kid would probably get denied because many of you have jobs and you have houses and things like that would disqualify your child. But once they're 18, not an issue. Even if they're under a guardianship, doesn't matter. The agency is really just looking at them at 18. For our older parents and caregivers, there is a benefit under the other program, which is all of these benefits that we know about, like RSI, like retirement and disability insurance, and like widows benefits, like survivors benefits when a worker passes away. Those are all falling under Title II of the Social Security Act, and those are all paid for with that FICA tax that comes out of your paycheck. So that Social Security percentage, that's all going to a trust fund, an actual trust fund run by the government that pays for all of these programs. And when a worker dies, or when a worker retires, or when a worker is pulling on their own disability benefit, there are benefits for their adult disabled child. So it's important to know about both of the programs because although you might get your young adult on SSI when they're 18, when you reach retirement age, they can be moved off SSI onto the adult disabled child benefit. And it's usually a lot more money because it's based on your own work record and the taxes you paid in. In addition to the SSI, anyone who's on SSI gets the Medicaid basic health care plan, but Texas also has additional Medicaid benefits, these waiver programs, like CLASS is one of them. Also the housing for like intellectually disabled individuals, group homes, that comes through Medicaid. Respite care for our families who need someone to come into the home for a few hours so they can run errands, that's under Medicaid. You would go to yourtexasbenefits.com for those special programs, and those are some of the ones that I was saying earlier that have like 10 to 20 year wait lists. As far as Medicaid programs, like these waiver programs, Texas is number 50 in 50 states.
Which is
So-
the best stretch?
I would say California, Massachusetts, New York. Yeah. But we don't pay income tax here in our state, so there's not the funding there. The funding's not there. The revenue is not there to pay for many of the programs that these other states have. In fact, like California supplements their SSI too. Like you get the federal SSI benefit, which is just $914, and then you get additional amount from the state. So it's really important to understand these programs and make sure you are getting on the wait list and applying for them early on. Other types of programs that you want to be familiar with are the Texas Workforce Commission, especially if you want your child to, or if your child wants to work. Many of our disabled kids, they want meaningful lives too, and having a job to go to is a really great thing for them. But I always talk to parents about making sure that when they're in the employment environment, if you know your child has significant limitations, especially socially, make sure it's an accommodated work environment. And to get an accommodated work environment, it's best to go through the Texas Workforce Commission. Too many times I've seen parents support their kids in getting a minimum wage job, thinking, oh, this shouldn't be a problem. And indeed, it's a huge problem. They might not be able to meet the demands. Even minimum wage jobs are very fast paced. Even if they have simple steps, they're very fast paced, and a lot of our kids can't keep up with that pace. They are also very front facing with the public, socially, and some of our kids have a lot of limitations there as well. And if they're not in an accommodated work environment, then they're gonna face the possibility of being fired from their job for not keeping up. And I will tell you that really impacts their mental health, because then they feel like they can't do it. They feel very unsuccessful, and that's very unfortunate. And sometimes even it leads to HR investigations and now an employment record that says they were terminated for cause. So I feel that it's, I do a lot of work with Social Security and vocational rehabilitation workers, and I feel strongly it's important that you utilize a program through the Texas Workforce Commission if you want your child to work, because you want them to be accommodated, and you want them to be prepared and ready, be successful. That's gonna help them. All right, and then these are some nonprofits, agencies that also assist. So if your child is working and getting SSI, some of these programs will help you figure that out. Easter Seals used to be the WIPA, which is Workplace Incentive Program Assistance, but during COVID, they lost the contract and it went to Imagine Enterprises. So if you have questions about the work programs for Social Security that allow you to get SSI and to have your child work, I recommend reaching out to them and getting with a WIPA, W-I-P-A.
And I just want to reiterate that. I know there's a lot of families that think if my child works, then they lose their SSI benefit. There is an adjustment to that. We did have a speaker talk about that, but that is not, I think that's just misinformation. And so I just wanted to say that one more time.
Yes, your child absolutely can work. There is a reduction. It's generally $1 for every $2 they're earning. But there's also ways to reduce their gross earnings by participating in some of these employment programs. It's rather than trying to explain it to you, I would say as soon as you get your kid on SSI, if they're working or they want to work or they have a job lined up, get with a WIPA, W-I-P-A, because Social Security pays those people to help you navigate Social Security's programs. Most parents are going to have no problem advocating on their own with Social Security. They generally do have issues with just what to expect. In my private practice, I do for a flat fee, like some coaching, advising parents about that process. Just because it's hard to navigate in terms of paperwork, steps, and what to expect. And then a lot of times parents call up Social Security and they try to ask a question and they get back weird information or incorrect information. And a lot of that has to do with the fact that the people answering the phone, some just barely have a GED, and not to say anything bad about that, but they're just not very knowledgeable about the rules, okay? And they don't really understand them, and then they're trying to explain them, and it's very convoluted. Like, I've heard very convoluted things from clients talking to some of those entry-level workers at Social Security. And then they also aren't allowed to give the public legal advice, so they can't tell you what to do. And that leads to a lot of frustration with my parents where they're like, oh, I have this question and I don't understand why I can't get it answered. So, yes, you might want some advising and guidance, but for the most part, you should be able to advocate for your child, especially if you're their legal guardian. All right, I think we have like 5 minutes, so
Yes.
I don't know like how fast I can go through this. You've probably heard it in other presentations. You can go to the next slide. If you haven't done your estate planning documents, I highly encourage you to do that. As I said from the very beginning, expect your child to outlive you. I did have one parent say that their plan was to pray to God that the child would be taken first. That's not going to happen. I believe in having faith, but that's not the right way to look at it. We have great health care. We've advanced. We are a more inclusive society, so even our special needs individuals are having more meaningful lives. That's leading to longer lives. You need to have a plan. Who's going to be that successor, and how are you going to be financially providing for your disabled child and their caregiver to make it comfortable for them as well. And we spell out those plans in these type of documents, especially you'll need a special needs trust if your child's going to be on SSI, because it's got that asset cap, right? It's $2,000. If you haven't heard, it's $2,000. That's been the rule since 1972. It hasn't changed. We ask every year to lift that. That's the rule. We're stuck with it. So we have to work with the things they do give us, which is special needs trusts and ABLE accounts. If you go to the next slide, I think it's my, these are all the special needs planning tools. We want to use all of them. And then if you go to the next slide, and the next one, this one I wanted to point out because if you call around private practitioners, I'm not going to lie, paying for a special needs trust is quite pricey, but if you can't afford it, there is a master pooled trust here in Texas, and it's got a low barrier to entry because it only costs $600 to set up the account, and you become part of a master trust that Social Security has already approved. The limitation there, though, is they only accept liquid assets, so cash. If you wanted to leave an estate behind that included personal property and like a house for your child to live in, this probably isn't the best answer, but it's something. And then ABLE accounts. Guardians are able to set up an ABLE account, and agents under a power of attorney can set up an ABLE account for their young adult child. And this allows you to contribute up to $17,000 in 2023. It'll be $18,000 in 2024 from all sources. And the distributions from these accounts don't impact SSI at all. So there's different rules for supplemental needs trusts. If you make a distribution for housing or food right now from a supplemental needs trust, it reduces the SSI benefit. But if you make a distribution from an ABLE account for housing or food, it has no impact. I don't make these rules, I just explain them. But, so I encourage parents to set up both a special needs trust and an ABLE account. Because the SSI benefit, as I said, $914 a month, it's really not enough. And so it's great to have these tools that can supplement what your child's receiving. And then this is just kind of like benefits of each, but I generally advise my parents have both. I think that should be my last slide.